Now let me submit something to you that I think that you're maybe missing the point on the standard of review. I think you may be looking at a blanker slate than you may think. Because as I look at Breza, I look at Duluth, I look at Stearns, none of those questions dealt with a fundamental right that's enshrined in the Constitution. They dealt with legislation that the legislature was to submit to the people. Question for you. Does this amendment affect voters' rights?
Yes.
Is our voters' rights a fundamental right enshrined in the Constitution?
Yes.
Isn't it game, set, match when you look at what Hamilton said in Federalist 78, Madison said in the Federalist Papers, Marshall said in Marbury versus Madison, and amplified in Fletcher versus Peck, is that the judiciary is to guard against the ill humors that may emanate from the designs of men and women, we should add, and that may emanate from the people. And so, if we're talking about the standard of review, when we're talking something so fundamental as voter rights, don't we at a minimum look at it with a skeptical eye? That's what's said in Crawford, or maybe even a gimlet eye, because it goes to the heart of what the Constitution is about. The Constitution is the people's document. And the right to vote is an institutional way to peacefully revolt. It allows us to reinvent ourselves. So aren't we looking at least something more than what we articulated in Duluth, Stearns, or Breza? I mean, they can inform us, but it doesn't get much bigger than this, sir.
Anderson, who kept saying, you guys have a blank slate, and was talking about that perhaps you erred and are focusing on the question when you should have been asking the court to strike down the entire amendment based upon constitutionality. Should you have done that?
I think that we proceeded with the right strategy. I mean, that was one justice. I think he raised an important issue, though, going forward. And, the court could still move in that direction if they so desired. I mean, the court has sort of broad ability to do that. I think we've questioned, the constitutionality of photo ID for quite a long time. And so whether that's, in hindsight, was that a better strategy? I really can't answer that. But I think overall, I think he raised some important questions throughout this and feel very confident about the outcome for today.
So you're saying then that the court could come back and say, it's not the question, it's the constitutional amendment itself. This is unconstitutional, we can't have it. You think that's a possible outcome?
That is a possibility because of what I think Justice Anderson said today. Whether that's likely, I mean, that was just one justice. I mean, it's always hard to read into what's going to happen based upon the questions today. We saw this with the healthcare vote. Everyone thought it was going to go down based upon the questioning, and look what ended up happening. And so today, it's really hard to sort of judge this. But based upon that, I still feel really confident because you saw almost every justice really question the question itself and saying it's deceptive, misleading. I think the real issue is going to be, what is the remedy? Do they feel it's too political, so they're not going to do anything? Do they feel that they're going to strike it down completely and they don't have the power at all to change the question? Or do they go for some sort of in-between step, which essentially would be strike the question but put the entire amendment on the ballot?